Hi, my name is Eric Early. I'm an attorney here in Las Vegas, and the problem is you just received your notice of default in the mail, and things are moving way too fast. You're going to be foreclosed on if you don't do anything about it within 3 months and 20 days. That's when you could have the auction. 3 months and 20 days is not very long. So let's talk about what you can do to throw on the brakes and slow the lender down. Well, the Nevada Foreclosure Mediation Program is designed for owner-occupants who want to slow things down, come to the negotiating table, and negotiate in good faith with the lender. Now you might be thinking, well, are they going to negotiate with me in good faith? I mean, come on. They have the gun pointed at my head, right? They're going to foreclose on my property and kick me out. Well, there are some tools in this program you need to know about. Let's start with the first rule. The lender, if you opt into this program, the lender must receive a certificate of mediation or they cannot foreclose. That's law here in Nevada. So they must get this certificate in order to foreclose. That gives you some leverage. They must show up and negotiate in good faith. But for you to operate in this system, you must opt in. And you only have 30 days from the notice of default. As soon as they record the notice of default, you have 30 days to pay $200 to the program administrator and present your documentation to them. If you don't, you're not in the system. Let's talk about some of the requirements, because these are the real hurdles, the real difficulties, the hoops that the lender must jump through, thanks to the new rules of the Nevada Supreme Court. The new rules require, and when I say new rules, it's effective March 1st, 2011. So if you heard anything about the system prior to that, throw it out. You got to listen to me. So what's required? Well, as always, they have to provide copy of the deed of trust, promissory note, and all the assignments, and they must certify that these are true and actual copies of the original. But this is where it gets good. They must also provide each endorsement of the note. Now, what is the note? The note's that document that actually evidences the debt that you owe to the lender. Now, these notes get transferred around in the secondary market. And a lot of times it's hard for the lenders to keep track of it because they have developed their own system outside of what is required by the UCC, the Uniform Commercial Code. And this system that the lenders have often used helps them lose track of some of this information. So just keep that in mind. They must have a separate certification for each endorsement and all these other documents. And this certification must say that they are in actual possession of the originals. Now, if you know anything about what's going on in the secondary market, you might get a grasp of how difficult some of the lenders are having, some of the difficult time they're having producing these documents, because producing it under oath is a big problem for some people. There's lots of laws out there against robo-signers now. If people are going to say under oath that they have the documents to foreclose on you, they better really have them, because there are criminal fines and criminal penalties associated with this now. If they say under oath that they have the originals, they better have them in their actual possession. So these are some of the tools you can use, and these endorsements are a big thing. So you might have the same lender, let's say Wells Fargo or Bank of America. You might have the same servicer, but the beneficiary of the note, the person who actually holds the note, the investor, who I'm talking about, they may have transferred this several times. And each time they transfer it, they need to endorse the note. They need to have some kind of endorsement. Kind of like if you wrote me a check and I endorsed the back, I could hand that off to somebody else. And then they could endorse that and hand it to somebody else. The problem is the only person allowed to cash that check is the person who has the original. Certainly the bank wouldn't allow me to come in and have a copy of that check that you wrote me and I say, hey, please pay me the $100. No, they're going to say, show me the original. Well, that's part of the problem. They're requiring, the Supreme Court of Nevada's new rules require that they have actual possession of the originals. If they don't, or if they don't have this certification under oath, again, a separate certification for each document, then they cannot get the mediation certificate. If they cannot get the mediation certificate, they cannot foreclose. Now what happens if they come out of the mediation and they cannot foreclose? They got to start over again. So what do? They file a new notice of default. And what do? Opt in again. You get another bite at the mediation apple. And some of my clients are in a perpetual cycle. Some of them like that, some of them don't. What is really the best thing is to come up with a resolution. And if they've screwed up the documents and you're in one of these cycles, you really have negotiating leverage. You can negotiate usually a resolution to the property such as a short sale. And that's probably the ideal situation. A short sale with them waiving their right to sue for the deficiency balance. Does this happen? Yes, it happens very frequently. Most of the time, the vast majority of my clients, they get with a very minimal cash contribution to the lender, usually in fact, it depends on your income, but usually no cash contribution at all. But if you have an upper income, you probably have some kind of cash contribution. But the idea is they waive their right to sue and they waive their rights to the deficiency balance. That's what you want, and that's what we usually get. And you can negotiate this often inside the mediation program. That's why this program is so good. It's why you should take advantage of it. You get more time. You can often negotiate an extra 3 months. So even though you might have taken 4 or 5 or even 8 months to get to mediation after the notice of default, you usually can negotiate another 3 months. Gives you even more time. But if they didn't come up with the right documents, who cares? You don't need to negotiate another 3 months because you're going to get at least another 4, right? Because they got to start the system all over again. You got to have someone helping you that knows the system, that can spot the flaws. And that's what I do. So if you want to give me a call, give me a call and I can help you with your mediation. It's 702-727-8384. We do charge $1,000 to go to mediation with you, but that's a very good bargain when you consider you get extra time in your property, and almost every time we're able to find some flaw in the lender's system, in their documents. Now I can't guarantee that we will every time. I have had lenders show up with all the right documents, but it is extraordinarily rare. And if you can buy yourself another 3 or 4 months, it's money well spent. Plus, you don't want to negotiate a short sale with the foreclosure date looming. It's like negotiating with a gun pointed at you. That's no way to negotiate. Take them to the foreclosure mediation program and make them negotiate in good faith. One of the things they've got to do when they show up at the program, they have to have an appraisal that is no more than 60 days old to negotiate from. They must prepare a short sale value of the property, an estimated value that they might accept. They got to come to the mediation with these numbers. If they don't have the appraisal, they got to do this whole thing over again. They cannot foreclose. It's a required document. So again, remember, they don't bring the right documents with them. No mediation certificate, they cannot foreclose. Give me a call, 702-727-8384. I'd love to help you with your mediation. Let's punch some holes in their documents, give you some more time, resolve your problems with this property. Thank you.